I beg to move that this House has considered E-Petition 300561, entitled Replace Breed-Specific Legislation with a New Statutory Framework. The prayer of this petition states, and I quote, that breed-specific legislation fails to achieve what Parliament intended, to protect the public. It focuses on specific breeds, which fails to appreciate that a dog is not aggressive purely on the basis of its breed. It allows seizure of other breeds, but the rules are not applied homogenously by councils. We need a system that focuses on the aggressive behaviour of dogs and the failure of owners to control their dog rather than the way a dog looks. Reconsider the licensing system. The framework must be applied by local authorities the same way, whereas currently some destroy dogs with no court order. It must be more strictly controlled than it is currently. The system needs to be fairer for all, dogs and humans. We are touched by cases of people committing suicide over the current system. When it closed, this petition reached 118,641 signatures, including 163 from my own Carshalton and Wallington constituency. Now, Mr. Paisley, as a dog owner and an animal lover myself, I feel very strongly that there are no bad dogs, only bad owners. I have owned breeds which have had a terribly unfair reputation, such as Staffordshire Bull Terriers, whereas in reality, as anyone who has owned one will tell you, they have the sweetest temperament and make great pets. However, certain dog breeds are banned purely based on their breed under breed-specific legislation. And in the UK, BSL takes the form of the Dangerous Dogs Act 1991, which bans the breeding, sale and exchange of 4 breeds of dog. Now, apologies if I get the pronunciation of some of these wrong. The Pit Bull Terrier, the Japanese Tosa, the Dogo Argentino and the Fila Brasilio. However, the law does allow a person to keep an individual dog where the court has considered that it does not present a danger to public safety. The court will consider the temperament of the dog and whether the intended keeper is a fit and proper person, and other matters such as suitability of the accommodation. Dogs placed on the index of exempted dogs may be kept by the owner under strict conditions, including that dog is neutered, microchipped, and kept on a lead and muzzle in public. Now, the Dangerous Dogs Act was in response to a spate of dog attacks at the time, and it was obviously well intended to try and reduce just that. However, I think it's fair to say, judging on the evidence and the discussions that I've been having since this petition reached 100,000 signatures, that the Act itself wasn't necessarily based on any particular evidence or any particular science in any great detail. It was really quite a knee-jerk reaction Act at the time, and the aftermath of the Act has suggested that actually it may not have worked as intended. Now, all major animal welfare organisations, including the RSPCA, the Blue Cross, Battersea Cats and Dogs Home, and indeed the DEFRA Select Committee report of 2018, have expressed their concern with breed-specific legislation, and I thank them for providing me with briefings prior to today's debate. The data suggests that the Act has indeed failed to achieve its intended purpose. These 4 breeds account for only a small fraction of legal cases brought under the Dangerous Dogs Act. For example, between 1992 and 2019, only 8% of cases involved these 4 breeds. Yet at the same time, the number of hospital admissions since the Act was introduced has risen from 3,079 in 1999 to 8,859 in 2020, which is an 188% increase. Campaigners have also pointed to other areas where the legislation falls down. It fails to tackle the issue of irresponsible owners because the focus is on the breed, which detracts from the real problem of poor animal husbandry, welfare and training of a dog. And every tragic fatality in the UK involving a dog attack has involved some element of neglect at the same time. It unfairly targets good dogs and fails to recognise that any breed can indeed be dangerous in the wrong hands and that any large dog can cause horrific injuries. It produces a crime where the burden of proof is on the defendant to prove that their dog is not a banned breed. This leaves the owners with an almost impossible task of proving a negative, which also seems contradictory to the principle of innocent until proven guilty. But the Act seems to fail in particular in regards to the pit bull. because this breed is not recognised by the Kennel Club or other dog organisation in the United Kingdom. Therefore, the seizure of these breeds of dogs have been very, very patchy and differently applied across the United Kingdom. The resemblance to an American Pit Bull seems to be the primary reason for this happening. Therefore, an injustice occurs when a dog is held to be this type of dog, when in fact it is a cross between, for example, a Staffordshire Bull Terrier and a Labrador, which is a very common cross which is seized because of its resemblance to a Pit Bull. There is also the issue of cost, because the cost of the taxpayer of kennelling these seized dogs has racked up to tens of millions of pounds per year, and even when exempted, a dog cannot then be transferred, cannot be left with others, must remain muzzled in public, even, for example, in private cars, and walked on a lead, even if there is no evidence at all that this dog is a danger to another human. Now, this leads to stress both for the dog and for the owner, and owners of seized dogs have reported high levels of stress, both for them and for their dog, because they're not sure if that dog will ever be seized again. And there's even been cases, for example, of a dog choking whilst it's been muzzled, and the owner being prosecuted for removing that muzzle to save that dog's life. Now, sadly, the law doesn't recognise the need of necessity, so therefore that dog would be liable to be seized and destroyed, even though it would have died had the muzzle not been removed. Now, this, in my opinion, cannot be fair. But there are also issues with the enforcement of this legislation, and evidence from Battersea, the RSPCA, Blue Cross, and indeed the evidence submitted to this 2018 DEFRA committee inquiry suggests that the application of this law is often a bit of a postcode lottery, with different police forces and local authorities taking very varied approaches, but there are a number of common themes. Well-behaved dogs suffer at the hands of this law because often the seizing itself is a very traumatic experience which is handled very brutally and heavy-handedly. The dog is then held in kennels for many months, which has an adverse effect on their temperament, and many good-natured dogs have been reported of being returned to homeowners with serious behavioural issues, separation anxiety being the most common. And there's been photographic and video evidence of injuries and severe malnutrition that dogs that have been kept by the police have suffered. But when information is asked about the kennel that they were kept in, no legal information is forthcoming to allow these dog owners to bring forward any prosecutions or legal challenges themselves. But it also doesn't effectively tackle public safety. It's indeed damaging for dogs and their families in many ways. There's reports of children being traumatised by watching their best friend being dragged away by the police. And scientific studies have indeed shown that young people often form incredibly strong bonds with a family dog, sometimes stronger than with their siblings. And removing an innocent dog from the home can have an incredibly negative effect on a child. Some owners have even been misled as to the nature of the seizing of their dogs, signed a document that wasn't properly explained to them, and the dog consequently destroyed, only to claim subsequently that they were not aware that this is what they were agreeing to. And there have been many, many accusations that the police have willfully misled owners in order to get a dog destroyed. On some occasions, a dog has even been destroyed without a court order or with the informed consent of the owner. When a dog is seized, it's not allowed to even have familiar objects around it, such as favourite toys. It's an incredibly stressful situation for a dog to be seized and put in a kennel. So to further add insult to injury, as it were, by denying a dog something familiar, seems to me seems to be cruel. And tragically, there have indeed been cases, as referenced in the prayer of this petition, of people committing suicide because they could not afford to apply to have their dog exempted, and the experience of having that dog removed and not knowing if it will ever come back has led them to make the decision to take their own life. Now, no one should be kept in this position, and there should indeed be adequate signposting for these people to put them in contact with the myriad of charitable organisations who might be able to help, but the evidence so far is that this is not forthcoming. Now, I appreciate that the government has set out very strongly in their response to this petition why they do not want to repeal this legislation, and indeed has the support of the police. And if I could speak frankly, I do see the political difficulty in doing so, because should any changes be made to the Dangerous Dogs Act and an attack consequently follow, the political fallout as a result of that would of course be severe. Even if there was little to no evidence that it was related to that decision in the first place. So it would not look good in many ways for that to happen. However, the petitioners, particularly the lead petitioner Gavin, who I had the pleasure of speaking to before this, have suggested a number of options to improve this legislation, not all of which, as I understand, would actually need primary legislative change. So I wonder if the Minister could take some of these suggestions back. I know that Lord Goldsmith has primary oversight over the enforcement of this legislation, so if she would be willing to take some of these suggestions back to see what could be done, that would be very welcome indeed. Some of these suggestions include reversing the burden of proof and requiring prosecution to prove that the dog is a banned breed rather than the other way around. Ensuring that the law requires dogs to be released in a timely fashion and enforce a strict time limit. Ensuring that owners are fully informed of the process and for the police to not accept an agreement for destruction at the point of seizure, with police ensuring that the owner has received any advice that they want and that they are fully informed of their rights. Ensure that those assessing the behaviour of dogs are independent of the police. Ensuring that the ownership of seized dogs remains with the owner and that the owner must be informed of all material aspects of the dog's care, requirements, veterinary treatment, etc. The removal of the requirement that a dog seized by reason of breed and not anything else it has done must be detained whilst its case is being considered. This is a waste of public funds and causes unnecessary stress both for the dogs and the owners. The dog should be able to remain at home if there's no evidence of it being a danger, and there is no reason to believe that owners wouldn't indeed cooperate with the authorities to make sure that reasonable arrangements were put in place. An assurance that dogs detained by reason of their conduct have their cases heard and considered, but with the option of compulsory training and behavioural work put in place rather than jumping straight to destruction. A call upon the police to use the principle that the aim should be to keep as many dogs alive as possible within the limits of public safety and not be minded towards automatic destruction. Prioritise the hearing of cases so that no dog has to remain in a cage for inordinate periods of time. And consider working with an organisation to establish a facility where dogs can be detained with a centre staffed by experts in canine welfare and behaviour, with complete transparency where costs would be reduced far below their current levels and partly funded by charitable donation. Now, I appreciate that DEFRA is currently in receipt of some new research from the University of Middlesex, I believe, that is currently being peer reviewed, so I know that the Minister will want to wait for that to happen before being able to tell us what that says. But I hope that we will be able to, that the government will be able to consider some of these suggestions that these charities, campaign groups and the petitioners themselves have brought forward, and indeed the DEFRA committee inquiry as well, which I think is fair to say was pretty damning of this piece of legislation, to seek to improve it, even if not bring forward primary legislation. And Mr. Paisley, owning a dog is indeed one of the most joyous and rewarding things that I've ever done, and I'm sure many people would say the same. And they can bring such happiness into the lives of families, but like any animal, they can of course turn if in the wrong hands. But the data tells us that breed is a poor indicator of the likelihood of violence, and a dog is only as good or bad as the person who owns it. So legislation should reflect that, but it is also clear that it is currently littered with issues. So I hope the government will commit to further reviewing this evidence and making improvements to the application of this Act.